Well, good evening, ladies and gentlemen, and thank you very much for joining us here as our Greenway series of CPD lectures continues, and this evening on the piece of legislation which is constantly evolving and is always in front of mind for those in the construction industry, the Security of Payment Act. You will be aware that a number of changes are proposed and have been passed by the legislature to that particular act. Those changes have not yet been gazetted, so they're not yet in force, but to try to get ahead of the curve, as it were, we prepared a paper on the suite of changes that were made, and that's been up on our Greenway website for some time now. We'll obviously adapt and adopt it depending upon the form of the changes when they ultimately come into effect. But for this evening's purposes, we thought we'd do three things. Firstly, I'm going to touch upon 4 decisions that have been handed down by the New South Wales Court of Appeal in the last 12 months or so, which deal with significant aspects of the legislation and how we can advise our clients about matters of adjudication and the application of the Act. Adele, Carr and Declan Byrne have then shared the burden of dealing with the changes that have been, as I say, passed by the Parliament but not yet gazetted, and they'll describe those changes for you in some detail. The third part of it, obviously, we'll try to open up for some questions. If people have any issues that have arisen in this legislation, it is common that they come up, and we're here as a Q&A type session to answer any questions that you might have, either presently for things that have happened in the past or things that you apprehend might happen in the future. So that's the structure we'll adopt. And we'll start now with the review of those cases that I referred to. The first decision was a case called Cochrane Constructions and Fulton Hogan Construction Proprietary Limited. I'm told I have to do this. Hey, and it works. So they're the references that you might have. I'll give you a brief, short description of each case and why they are relevant for your consideration, and you should know the contents of them. The first one, Cochrane Constructions and Fulton Hogan, I'll just call reasons. This is a case in which the New South Wales Court of Appeal considered the adequacy of reasons provided by an adjudicator and whether those reasons, A, were adequate, and B, if not adequate, that then vitiated the determination and rendered it a nullity. There was complaint made at first instance that the adjudicator had formed views based on reasons that she had not expressed, or indeed that her reasons were so lacking in quality that they could not properly be regarded as reasons. The principal decision was given by Justice Baston, who observed, pursuant to the terms of the Security of Payment Act, that the obligation of the adjudicator under Section 22 is to provide a determination in writing which includes the reasons for the determination. Now, those reasons can be short, they can be peremptory, they can even be wrong at law and wrong in fact, but nonetheless, if reasons are given, then ordinarily that is sufficient for the adjudicator to discharge the statutory function provided for by Section 22. The relevant passages of that decision, if you would like to take some shortcuts, I'd suggest you start at paragraph 33 and go through to about paragraph 40, which concludes that the adjudicator's ultimate function is to determine the amount and timing of a progress payment, and by its nature, the obligation of Section 22(2) required a process of evaluation sufficient to warrant the description as consideration in the particular context and not merely formalistic reference to those matters. And the process adopted by the adjudicator in this case did not cease to warrant that description merely because it included a conclusion that one provision of the contract in that case was not to be provided, or applied, I should say. And that remains so whether or not the conclusion proceeded from an error in construction or a wrong understanding of the applicable law. So for some considerable time there was a number of cases which concerned the adequacy of reasons and whether or not an adjudicator had properly detailed the reasoning process and the reasons for their consideration. This decision really stands against that sort of application unless you have a situation where an adjudicator has clearly on the face not given reasons or somehow stated a conclusion without any reasoning at all, then that sort of challenge to an adjudication is unlikely to succeed. The second case that we've got up there is one called Goodwin Street Developments and DSD Builders. Actually, no, it's not. That's the third dot point. Well, I'll deal with that one first because it's where it appears in my folder. Goodwin Street Developments and DSD Builders was an important case, and I'll just describe this with the title Good Faith. There, for a considerable period of time, were a number of cases which considered whether an adjudication determination could be found to be invalid or void because an adjudicator had failed to engage with the intellectual process, to grapple with, was the phrase I think used certainly in one of the decisions by Justice McDougall in the Lang O'Rourke decision, with respect to the process of determining what the issues were and what the outcome should be. And the question as to whether or not there had been an engagement by the adjudicator in good faith came from a remark from Justice Hodgson in the decision of Byrne, where it was said that the adjudication would be valid unless it had not been undertaken in good faith. And they then developed, consistent with the law generally with respect to good faith, two questions or two aspects of good faith that needed to be considered. The first is somewhat in a shorthand way called hard good faith, and that means fraud. A lack of good faith in the sense of mala fides, bad faith, approaching the task informed by interests or matters outside the actual terms of the remit, so that what is actually produced is the product of fraud. The second aspect of quote-unquote good faith is what's called soft good faith, which is simply without any mala fides or some sort of ulterior motive or purpose, failing to actually engage with the process of adjudication in this case, or determining the matter that is afforded to that particular person for determination, and failing to then produce what was required. So they developed a line of cases which said that reference to good faith meant the adjudicator grappling with or engaging with the intellectual process of considering the issues that were raised pursuant to their obligations under section 22(2) to look at the contract, the claim, the schedule, the duly made submissions and any site inspection. And where that had not occurred or it was not apparent on the reasons that had occurred, then the determination may be void. The Court of Appeal said, we've had enough of that, we're not going into that area anymore. When Justice Hodgson in Brodin said good faith, he meant the first kind, that is to say mala fides or fraud. And if you're not alleging that, then please don't use the words good faith before us again. What you need to do if you wish to challenge the adjudicator's exercise of power is identify a statutory function that the adjudicator had to undertake to consider, or a failure to consider, something that was not within their power. So if they consider something outside the terms of the provisions of section 22(2), or they don't consider something that is within it, then the argument may be that the adjudication is void for failure to perform statutory function. But that conceptualisation of invalidity should not be confused with notions of good faith which arise in equity and other spheres where individuals who are charged with doing something and in doing something to a particular standard still don't get there, but are not, as I say, informed by some sort of ulterior purpose or fraud. So the decision in Goodwin Street Developments and DSD Builders is certainly an important one, and again the principal reasoning was given by Justice Baston, and the consideration of the historical concepts of good faith, particularly in the context of jurisdictional error, starts at around about paragraph 12 and ends at about paragraph 29. And in short terms, the reason that Justice Baston at heart was concerned that the court not consider issues or notions of good faith in a soft sense was because he considered it a slippery slope to merits review. And if you're starting to look at those things, he certainly felt that it may become perhaps not an excuse, but a misconception that involved a merits review, which has obviously been excluded for some time, certainly since the recent High Court decisions that we're all very familiar with. My third case, the second one on the slide, of Icon Construction and Australia Avenue Developments, I would just call this one powers or jurisdiction. And this case concerned a decision at first instance which considered the content of a payment claim and considered whether or not an adjudicator had incorrectly approached the payment claim and made a determination of matters that were not within the payment claim. The judge at first instance said that is what had occurred, and in those circumstances the determination was void. The Court of Appeal disagreed, and it disagreed basically on a distinction of what might be called jurisdictional fact. And again, Justice Baston, who has been busy in this space, said that it was a fundamental principle that the engagement of statutory power may depend either on the existence of an identified state of affairs or a state of satisfaction of the decision maker as to an identified state of affairs. And in the first category, the actual state of affairs, being the criterion of engagement of the power, is described as a jurisdictional fact, meaning that the lawful exercise of power ultimately depends on a finding by the court exercising judicial review as to whether or not the required state of affairs existed. An example of that would be whether or not there was a construction contract between the parties, or whether or not a reference date had arisen, or whether or not, such as in the case of Chase Oyster, a requisite notice had been given such that the parties could then proceed to adjudication. The second category, which is sometimes also said to involve a jurisdictional fact, but only in the sense that the relevant fact is an opinion formed by the decision maker, and in that case a reviewing court can only be concerned with the existence and lawful formation of the opinion. Matters that fall within that category, certainly in this case, were what was the content of the payment claim. This was something that was given to the adjudicator to determine, having regard to the provisions of Section 22, and in particular Section 22(2), which specifies the matters that the adjudicator is to consider. So this particular decision of Icon and Australia Avenue Developments is important insofar as parties are facing questions or wish to consider questions of jurisdictional error. And it is important to identify that whilst the jurisdiction of the adjudicator may depend on the factors found, or it may also depend on the opinion of the adjudicator as to the factors found. And a useful checklist, certainly in my view, is the one that I expect we're all rather familiar with from the old decision in Byrne. That paragraph 54 of Justice Hodgson's decision seems to have stood the test of time, what he described as basic and essential requirements. The last decision that I just want to quickly describe is one called Seymour White Constructions and Ostwald. It is a very long decision. It's a bench of 5, and it was a bench of 5 because they were considering whether or not the Victorian Court of Appeal approach to a particular issue was right or wrong. They found it was wrong. The particular issue in that case was whether or not, well, there were a few issues, but the two principal issues that I think the case commends itself for, leaving aside His Honour Justice Leeming's explorations of the remedy of rectification in both common law and equity, are firstly whether or not the Security of Payment Act is available to claimants that have been placed in liquidation, and secondly, whether or not an where a party has a right under the Act to say judgment under Section 16 because there's a scheduled amount of X, but it elects to go to adjudication, and the adjudication determination is ultimately void, can they then step back and say, well, now I want to get my judgment under Section 16? And the Court of Appeal said, yes, it can, because whilst those remedies are exclusive, if the determination remedy is ultimately invalid because of whatever matters that create that invalidity, it doesn't then automatically exclude the right to seek judgment under the Act. So, however, where, of course, you get a valid determination, if you don't like it, you're not permitted to go back and say, right, now I want to have a crack under the Act. So once you make that step, if the determination is valid, you're stuck with it for good or ill. If it's invalid, you are then back to the point of making an election under the Act to either seek the judgment for the scheduled amount or to proceed to adjudication again. But the more important issue, at least in terms of the conflict on either side of the Murray River, was whether or not the Act applies to companies in liquidation. And the principal reasoning was given by Justice Sackville, with whom all of the other members of the court agreed, some with elaboration, some with none. And Justice Sackville essentially found that the Victorian decision of multiplex and facade, or facade and multiplex, Declan will correct me on that. Sorry?
Second one.
The second one, thank you. Which one did it?
Facade.
Facade and multiplex, thank you. Good junior. So that it was incorrect. And basically what he found was that the decision of the Victorian Court of Appeal was incorrect simply by reference to the text of the Act, which said that the only criteria that specified for a party to be entitled to a progress payment is that person has undertaken to carry out work under a construction contract as defined, and a reference date under the construction contract had arisen. Those being the only two stipulated criteria for being entitled to get a progress claim, there was no need then to go into any further implied limitations or to suggest that right could be lost as a result of subsequent events, even the placement of a party or a company in insolvency. And he made certain observations concerning the process of insolvency, finding that insolvency is a circumstance whereby a party is unable to pay its debts as and when they fall due. And a party which is insolvent may nonetheless have a surfeit of assets over liabilities. So ultimately, it may very well be able to pay all of the creditors, and then at winding up, the monies will be distributed accordingly. So there's no reason in those circumstances to exclude a company placed in liquidation from the provisions of the Act, particularly where, as was the case here, what that party is seeking to do is to enforce or at least recover a judgment sum for a scheduled amount, not necessarily a disputed amount, although that wouldn't really matter logically, but nonetheless where you have a situation here where effectively there's been an admission by the respondent that yes, I owe you X dollars for your payment claim, it is a little hard to see why that right shouldn't be able to be enforced pursuant to Section 16 of the Act, simply because the company is now in the hands of liquidators rather than those that were otherwise running it. So it's an important decision, although it may become moot, because one of the changes that Declan and Adele are going to talk about is the fact that the legislature has decided that no, in fact, the Victorians are right, and if you are in liquidation, you can't use this particular process to recover your debts. But as it stands at the moment, the Court of Appeal decision in Seymour White is the law for New South Wales, and the fact that your claimant has been placed in insolvency and is perhaps undergoing the processes of 553C of the Corporations Act does not preclude it from seeking to recover monies pursuant to those processes that are available under the Act. So those are the four cases that I wanted to touch upon and talk to as part of the initial part of the presentation, the CPD presentation. I'd now turn to the first of those that are going to be talking to you about the impending changes to the legislation, Adele Carr. Adele's been a member of our chambers here since 2016. She specialises in construction litigation and is well across, and always has been, the statutory provisions that apply as well as the contractual and common law aspects of construction. So Adele, if I could introduce you and ask you to tell us all about what we're going to see by way of changes. Thank you very much.
Thanks, Frank. As Frank mentioned at the very beginning, this Amendment Act hasn't commenced yet. Indeed, we anticipate that it's probably going to be commenced in tranches, partly because of the substantive changes that have been made, also because of the subordinate legislation that also needs to be made. Given that we're in caretaker mode at the moment with our impending election, it's probably no surprise that none of this has happened just yet. In addition, you would also note that part of the Amendment Act is that these won't apply to contracts now. It's contracts that once the Act commences. So indeed, we can start to gear up and prepare for these changes. Hopefully, you all have a copy of the Amendment Act. It's really designed to be as an aid memoir for this presentation. I certainly don't expect you to take it home, though you're encouraged to. But if, like me, you like things digitally, you can certainly download it and put on your iPad as probably a screenshot. Turning to the first amendment, and indeed, Declan and I are only going to cover a few of them, not all of them. One of the biggest changes that is going to be introduced is the removal of reference dates. That's currently considered in Section 8 of the current Act, which states, on and from each reference date under construction contract, a person who has undertaken to carry out construction work under the contract or who has undertaken to supply related goods and services under the contract is entitled to a progress payment. Now, indeed, the current Act does define what a reference date means, and that is a date determined by or in accordance with the terms of the contract as the date on which a claim for a progress payment may be made in relation to work carried out or undertaken to be carried out, or B, if the contract makes no express provision with respect to the matter, the last day of the named month in which the construction work was first carried out. So indeed, what you would see in the paper that's in front of you is that the right to a progress payment is no longer triggered by a reference date. It is simply that you have undertaken construction work. What you see up on the slide and that's in front of you is that Section 8 will now read, a person who, under construction contract, has undertaken to carry out construction work or to supply related goods and services is entitled to receive a progress payment. Now, linking in with Section 8 is Section 13, which is progress claims, and indeed you'll find that on page 4 of the document in front of you. What the Amendment Act is going to introduce is, relevantly at Section 13(1)(a), is to introduce a new regime whereby the statute defines a default timing for the making of payment claims, namely on and from the last day of the named month in which the construction work was first carried out under the contract and on from the last day of each subsequent named month. Now, this default position, as you'll see under Section 13(1)(b), can be deviated from with any contractual provisions, but those contractual provisions must be earlier. Also, Section 13(1)(c), you'll also see that even if a construction contract has been terminated, a payment claim may be served on and from the date of termination. Now, these sections probably will be embraced, and indeed will have to be embraced by the industry, but it does raise a few issues, and two of which I'd just like to highlight. One of them is in relation to milestone payments. Now, that term is currently defined under the existing Act, being that a payment that is based on an event known as a milestone. The definition of milestone is also included in the definition of progress payment. However, the definition of progress payment is not amended under these new changes, and indeed there is no link between Section 8 and Section 13 to a milestone payment. or milestone rather. So therefore it's probably open to construe that any contractual milestone payment regimes are in fact negated or even void under the new section, particularly section 13(1)(a). The other issue that does arise with these new sections as well is the any contractual impediment with respect to including supporting documents. This is separate to a supporting claim that might arise for the making of payment claims. Again, that requirement is not included in the new section. It is simply under Section 8, the fact that you have done the construction work. That is what entitles you to make a progress claim. The other additional sections that will be amended is sections 13, 5 and 6, and that's on the next page, page 5. Section 13(5) limits the number of payment claims to 1 each month, again though unless stated in the construction contract. And section 13, subsection 6, relates to subsection 5 being the number of times that you can make a payment claim in a month, that a claimant is not prevented from serving a single payment claim in respect of more than one progress payment. A claimant is not prevented from including in a payment claim an amount that has been the subject of a previous claim, and a claimant is not prevented from serving a payment claim in a particular month for construction work carried out in a previous named month. Now, probably the easiest amendment which we're going to see is we're going back, and I've put up there an oldie, maybe not necessarily a goodie, that a payment claim must state that it's made under the Act. Indeed, this requirement now has received mixed reviews, but indeed it's certainly not an onerous task for anyone. One of the most expansive changes, though, that the Amendment Act it will introduce is investigation and enforcement powers under Part 3A. What is interesting about the introduction is that this was not recommended in the Murray report. And indeed, these changes, or the Amendment Act, was introduced because of the Collins inquiry and the Murray report. So it's unclear where this came from. It does introduce expansive and broad investigation and enforcement powers, and indeed they relate back to fair trading. An authorised officer, you'll see, is defined to mean a person employed in the Department of Finance, Services and Innovation who is appointed under the Act, or an investigator appointed under the Fair Trading Act. Authorised officers can require people to provide information or records and answer any questions, and indeed they have the ability to enter premises and inspect and seize records. If and how these powers are going to be used, this is yet to be seen. If a corporation or a person fails to comply with any request for information or documents that is made by an authorised officer, or if a corporation or a person in any way hinders or obstructs an authorised officer, the maximum penalty to be imposed on a corporation is $4,400, and for an individual is $2,200. If a corporation or a person provides false or misleading information to an authorised officer as they're conducting their investigation or reviews, the maximum penalty for a corporation is much higher at $55,000, and for a person is $11,000. What is also interesting with these powers is that an authorised officer can issue an infringement notice, so it's effectively an on-the-spot fine. And just like traffic infringement notices, these can be appealed in the usual way to the courts. There are anticipated changes to the regulations as well. That will be the subject of our next paper, which will be coming up hopefully in the middle of the year. And we anticipate that we'll probably see some amendments to the regulations that will include more on-the-spot fines. The other part of 3A that will be expanded as well is the penalties and offences. The amount and quantum of penalties, as you've seen, has been increased, but also now the offences that can be committed by directors. And this is at anticipated section 34D, which you'll find that starts at page from 14 and 15 of the document in front of you. Directors who are involved in the management of companies and involved in the provision of construction work are now going to be held responsible for any act that they may commit themselves or as an accessory. Section 34D will introduce offences which attract executive liability, which indeed Parliament has flagged is going to be the most serious. There are a number of offences now under the Act which attract executive liability, but the one that I'd just like to point to is Section 13 of the Act relating to supporting statements. So that's Section 13(7) and 8. Now, indeed, these penalties have increased for anyone who provides a false and misleading supporting statement from 200 penalty units to 1,000 penalty units. So in monetary terms, that's $22,000 to $110,000. The risk of imprisonment has actually been removed, and when this bill was introduced to Parliament, they said that the increase in penalties was to act as a deterrent, what we see in criminal jurisprudence. I would have thought that keeping in the risk of imprisonment would have been a greater deterrent, but apparently increasing penalties was the way to go. With the executive liability that is now attracted to Section 13(7) and 8, this is essentially a personal liability for directors if they know or ought reasonably to have known that offence would be committed and that they failed to take all reasonable steps to stop the commission of that offence. And the penalty that attracts for that is $22,000. Again, with the introduction of the regulations, we anticipate that the types of offences that will fall under executive liability will be expanded. Now, Declan's going to continue on with the changes and will address residential applications.
I seem to have dropped a slide. Good afternoon, everyone. I'm going to deal with the remaining changes that Adele hasn't dealt with. There's about half a dozen to get through, if you just bear with me. The first one that I'm going to deal with is the current residential exception. Ignore the slide, it's gone missing. Is the residential exception. So for those of you who are familiar with the Act, and I'm sure you all are in great detail, the current Act says that the Act does not apply to a construction contract for the carrying out of residential building work as defined by the Home Building Act on such part of any premises as the party for whom the work is carried out resides or proposes to reside. And that's in Section 7(2)(b). Now, this is a pretty narrow exception. It doesn't apply to a lot of buildings. And this is because a couple of principles. Firstly, the cases tell us that a corporation cannot reside or propose to reside. So immediately, we know that this exception does not apply as it currently stands to any corporate developer. And we know this because of the Court of Appeal in Advance Earth Movers and FUBU, 2009 decision of the Court of Appeal, where His Honour Tobias noted that when one looks to the Home Building Act, one can see the clear indications are that residence is to be used in its natural sense. First, the Act is the Home Building Act, and a home is where natural persons eat, drink, and sometimes marry. I'm not quite sure where that comes from, but anyway. Next, the flavour of Section 7.2b of the Act is that the relevant party must have or intend some personal occupation of the residence. Thus, in my view, residential building work performed for a corporation cannot fall within the exception. So that's the first reason the current exception is quite narrow. The second reason is that the Court of Appeal also tells us that the work under a construction contract, so where the only work under a construction contract relates to the area where the respondent resides or proposes to reside. So that means that this exception does not apply where there are multiple lots in a development. So even a duplex, even if you're an individual developer, obviously you could only reside in one of them, and that means that you won't fall within this exception. So obviously it's common practice for a developer to hold back one unit in a big tower and to live in. That's not sufficient to get inside this exception. All the work under the contract has to be in relation to the area you propose to live in. So this comes from His Honour Baston in Shorten and David Hurst again. His judgment is somewhat dense. It was later summarised by His Honour McDougall in the case of, I'm not going to be able to say this, Opidisano and Micos Aluminium Systems from 2012. And what His Honour McDougall said in describing the Court of Appeal's reasoning in David Hurst was that on the proper construction of Section 7.2b, so the residential exception, the construction contract, if the Act is not to apply to it, must be one for the carrying out of residential building work only on that part of any premises in which the respondent resides or proposes to reside. So essentially the impact of these cases is that the exception as it currently stands really only opts out the mum and dad developers or renovators. So the amending Act that we now have deletes that exception. So now pretty much everyone is covered by the Act, and it's going to be interesting to see how mums and dads deal with these applications. So the equivalent acts in Tasmania, WA and Northern Territory already allow claims to be made in respect of domestic applications. Although, interestingly, the Tasmanian legislation makes it a bit easier on the punters by giving them 20 business days to put on a payment schedule rather than the 10 that everyone else has to deal with. This hasn't been adopted in New South Wales for whatever reason, so it's still going to be a strict 10-day requirement. So not surprisingly, the Murray report, who canvassed all the building stakeholders, said that the majority of those stakeholders were largely or very much in favour of the Act being applicable to residential building work. Obviously all builders, whether it's commercial or residential, want to get their payments as soon as possible and want all the tools in order to do so. So what John Murray said in his report in this regard was that there seems to be something inherently incongruous as to how a legislative scheme that has been designed to improve the payment practices within the industry will only permit one group of contractors to avail themselves of the benefits of the legislation, and yet on the same building project, another type of contractor would be deliberately shut out of the process. True, the relationship between a residential builder and a mum and dad owner-occupier is of a different nature to that of a builder and subcontractor. The fact remains that residential builders face similar cash flow issues to subcontractors when they don't receive prompt payment for their work. So I think that is going to be one of the big changes that's going to come, and it'll be very interesting to see how the residential market adapts to this change. Okay, I think I've caught up with my slides. So the current Act, Section 26, allows an adjudication application to be withdrawn only in two circumstances. The first is if the claimant doesn't receive a notice of acceptance of an application from the adjudicator within 4 business days after it's made, and the second is if the adjudicator who accepted the application fails to give us a determination within time. There's no ability to withdraw for any other reasons. So a common one encountered is if the parties settle, there's no express power to withdraw, although anecdotally I understand that the adjudicators are usually pretty happy to hold off issuing a determination and to stop work if the parties consent on the basis that their fees are paid. But more importantly, there's no power to withdraw and make a new application if an adjudicator withdraws himself or herself or is disqualified for a conflict of interest. So obviously this can give rise to all sorts of issues. So we have the new section. Actually, before we get to what we have in the new section, it's interesting to look at what the equivalent acts are in the other states and territories. So the South Australia is currently the only jurisdiction to have an express power in their act to submit a new application where the adjudicator themselves withdraws, and it's only WA and Northern Territory that has an express power to put in a new claim where the adjudicator is disqualified. Okay, so turning now to the Amendment Act, and we've got a new Section 17A, which, as you'll see, allows a claimant to withdraw an adjudication application at any time, both before an adjudicator is appointed and, as long as they haven't reached their decision yet, after an adjudicator has been appointed. Do it just by simple notice to the ANA copied to the respondent. The interesting part, and what's likely to be the controversial part, is in subsection 2. So the respondent does not have to go along with the withdrawal. They can object to it, and in which case it becomes the adjudicator to determine whether it's in the interests of justice to uphold the objection. Now, I think there's going to be some interesting case law on that, because adjudicators obviously like to find that they have jurisdiction, then they can charge more. But traditionally it's a claimant-friendly jurisdiction, so I think that puts them in a quandary. Do they agree with the claimant and deprive themselves of making a determination and billing for it, or do they hold us in the interest of justice to let it go? So this provision, that subsection 2, is actually based on a similar provision in the Northern Territory Act. For those playing at home, it's section 28 capital A3. There hasn't been any case law on that I've been able to find, but I think that's going to be an interesting section to watch. Okay, the next change we're going to look at is the ability to set aside part of a determination. So firstly, let's look at what the current state of play is. The Act is silent on what happens once a jurisdictional error is found at the moment. But we know from very early cases on the legislation, going back as far as Multiplex Constructions and Lukens back from 2003, that jurisdictional error invalidates the whole of a determination. In that decision, His Honour Justice Palmer noted that the whole of the determination must be quashed if jurisdictional error infects any part of the process whereby the adjudication amount has been produced, although he went on to note that this is no doubt a highly inconvenient result. However, I do not see any means of avoiding it as the Act presently stands. So it's taken 16 odd years, but the New South Wales Parliament has finally taken up those comments. So what we have now is the new Section 32A, so which allows the Supreme Court in any matter arising under a construction contract, the court can make a finding that jurisdictional error in relation to an adjudicator's determination. The court can make an order setting aside the whole or any part of the determination. And subsection 2 allows the court to confirm the part of the determination not affected by the error. So the Murray report tells us was overwhelmingly supported by the industry, and it's clear why it got adopted. This provision is also consistent with the Victorian Act. It's in different words, different language, but their Section 23 2 capital B provides that an adjudicator's determination is void to the extent that an adjudicator has taken something into account they shouldn't have. So it's an extension beyond that, which it'll be interesting once again to see how this one is adopted by the courts. Because particularly in one sense, a jurisdictional error usually affects the whole of the determination, so it'll be interesting to see the cases where it doesn't. Okay, the next one is the one that Frank foreshadowed earlier. So what happens if a claimant is in liquidation? Can you use the Act? So the current Act is silent. We have to look to the case law. So the Victorian Court of Appeal in Facade, Treatment and Brookfield found that the claimant in liquidation could not use the Act. Now, as Frank said, Stevenson, His Honour Stevenson at first instance and the New South Wales Court of Appeal on appeal overturned, well, didn't overturn, but found that that reasoning was wrong, plainly wrong, and went the other way. So the current position in New South Wales is that an entitlement to a progress payment under the Act does not depend on a claimant continuing work. Therefore, notwithstanding the winding up of the contractor in that case, the Act continued to apply and it was entitled to pursue its claim to judgment. Now, interestingly, the Murray report, when it was written, recommended what it called a codification of the existing law, which at that point was just the Victorian decision. So he recommended, Mr. Murray recommended that a prohibition on using the Act be put in place for companies in liquidation. And that's what we have now. We have a the new section 32B. So the first subsection provides that a corporation can't serve a payment claim or take any action to enforce a payment claim, which presumably means enforcing a statutory debt, or an adjudication determination. So, and what's even harsher for companies that enter liquidation during a drawn-out adjudication process is subsection 2, which says if a corporation in liquidation has made an application that is not finally determined immediately before the day on which it commences liquidation, the application is taken to be withdrawn. So automatic withdrawal if you end up in liquidation at some point in the process. It's a pretty harsh result for companies hoping for a last bit of payment through this Act before they give up and go into liquidation. Okay, the next one is just a pretty simple and easy one. So the current Act, as I'm sure you're well aware, requires principals to pay head contractors within a maximum of 15 business days, and for head contractors to pay subcontractors within a maximum of 30 business days. Mr. Murray in his report recommended that the subcontractor payment terms be tied into 25 days. New South Wales Parliament in its wisdom's gone beyond that and said 20 business days is the maximum. So we're shaving off 10 business days from what currently exists. I'm sure there will be happy subcontractors around. Okay, the last change, there we are, there's the residential one. Last change I want to deal with is the code of practice for ANAs. So a lot of people may not be aware, but the Department of Fair Trading actually currently publishes a code of practice for authorised nominating authorities. It's on their website. Includes a bunch of different requirements. Most of them are things that you'd expect. For instance, an ANA must have a process for recording the time and date of receipt of an adjudication application, a response, request for a certificate, and the like. An office bearer or employee of an ANA can't refer an application to another office bearer or employee. An ANA must, without discrimination, accept an adjudication from any applicant who pays the fee. There's also various reporting obligations, and there's requirements as to the selection, training, and monitoring of adjudicators. Now, importantly, the current Act does not include any obligations for an ANA to comply with that code or any punishments if they don't. But that has now changed. So we now have a new section 28A. So the first subsection gives the Minister the power to publish a code of practice. And then subsection 4, if an ANA contravenes a provision of the code that's designated an offence provision, guilty of an offence, which is punishable by up to 50 penalty units. That's a pretty low fine, but I think the bigger implication is in section 5, if you can read it, which is that the Minister may withdraw a person's authority to nominate adjudicators for the purposes of the Act if they are satisfied that there's been a contravention of the code of practice. So I think that could have a pretty serious impact on the ANA's business if there is contraventions. So we don't know what the code of practice is going to be, but we assume it's going to be based on the existing one that's published on Fair Trading's website. But it'll be interesting to see what is actually published by the Minister. So that has been the high-level changes that are made by the Amendment Act. I will, I think, now open the floor for questions that I will direct to Mr. Hicks.
Well, I have a question for you, actually.
Sure.
Before we start. I'm intrigued by this proposition that part of an adjudication determination can be set aside. What happens then? is the part that's set aside capable of being resubmitted to adjudication? Do you have to issue a fresh payment claim? It's because, of course, it's the claim that gets adjudicated upon. And you then end up with a divided situation where you've got a valid determination for some of it, and then you resubmit the payment claim for the parts that are invalid because of jurisdictional error.
Yeah.
And you inform the new adjudicator that they're not to touch these parts but deal with those parts, or how have the Victorians dealt with it?
Well, the Victorians, I should start by saying John Murray did consider submissions about whether you should be able to remit back to the original adjudicator where that happened. Although in their wisdom, Parliament's decided not to do that power. I think in the end he looked at the various case laws and decided that that was remitting an adjudication back to the original adjudicator wasn't the appropriate course of action. So we're sort of left in this, the Act doesn't prescribe what happens. So it's a lacuna of the law, I think. Presumably you would have to issue a new payment claim and go through the process again. But then I wonder if you issued an identical payment claim, whether you're going to have dual corp issues as well on the next go round.
Well, the only reason I asked is that one of the cases I was looking at, of course, dealt with the question of if there is an invalid determination, you then get set back to the point where you may have rights to get judgment, etc., on a payment schedule that was issued that you weren't perhaps happy with. But where do you go from there?
Exactly.
So we've just identified problems with drafting. So.
First time ever.
Exactly. My God. Bolt the doors. Okay. Well, thank you for that. So it's a problem no one's solved and hoping will never arise.
No.
All right. Well, does anyone else have any questions for Declan while he's standing there, or
anyone?
Any of us?
Just maybe a question for everyone in the room, more out of curiosity than anything else. I mean, we've seen Justice McDougall deal with circumstance where, for example, a supporting statement hasn't been issued, like the validity of a payment claim. But Adele, you're talking about some of the penal provisions. Has anyone actually seen them being implemented by the Department of Finance Services?
Not the department, but we have a case.
I've certainly seen a number of people referred to the department by people very unhappy with the content of supporting statements and alleging that they were erroneous, perhaps knowingly erroneous as well. Just on the question of whether or not the claim requires a valid supporting statement, there is divided authority at first instance on that point. Justice Ball has taken a different view to Justice McDougall, although Justice McDougall's reconsidered his view since that case and somewhat surprisingly concluded he was right in the first point. So, but nonetheless, it is a point that as the current state of the law stands, there is divided authority at first instance, and it may very well need to be determined by the Court of Appeal. Justice Ball says it doesn't invalidate service and the claim is still good. Whereas obviously Justice McDougall, and I think Justice Marr as well, and Justice Hammerstein.
Which is, I think, why McDougall is honest, kept to his original judgment, because Justice Marr followed.
Just to say, well, I've already decided this, and how dare anyone disagree.
He said because
he did actually say that Ball's decision. It wasn't the ratio, it was only over and in the decision that Justice Marr addressed the issue, it was the ratio, and in those circumstances he felt that as it was ratio, it was compelling authority rather than simply overturned there by observation. So, but nonetheless, it's still out there, so if anyone's...
But Justice McDougall made some comment in that recent case about how he was attracted by the reasoning in Ball's decision.
Yeah, he did. He did say that.
Which, I mean, it's got to be an interesting issue for the Court of Appeal, I think.
Yeah, well, I actually was there before Justice McDougall urging Ball. He was quite courteous about it, but but certainly that I think the severing, although I'm not too sure how frequently it's going to arise, having regard to the cases that I touched upon earlier about the Court of Appeal's view at the moment seeming to be that it's rarer and rarer that there will be jurisdictional error. Certainly once the adjudication process is established, that is to say there is a contract, claim is properly served, notice is given where they have to be, it's far harder to then identify how and where an adjudicator would err or fail such that the determination itself was invalid.
Any other questions? No? Brilliant. Okay, well, if you'd like to join us for some, I think we've got some refreshments and some food. Thank you for coming.
Thank you very much.